Article 18 has propelled us to move from a culture of authority to a culture of justification. Culture of authority where those in charge could just do whatever they think and wanted to do. That is the culture where we're coming from. To a culture of justification where a decision must be justified. One way of justifying it is say, you provide reasons. Why did you take reasons? And this is confirmed in the guide with rich Namibian jurisprudence. The guide is also affirming that the courts have actually done almost the unthinkable, has broadened the conventional way of, has extended actually the conventional understanding of administrative justice. The courts, as the guide is showing, has reviewed and is currently also still reviewing decisions which does not ordinarily amount to administrative decisions. Decisions of cabinet, decisions of the Speaker of the National Assembly, they are not reviewed as the guide is indicating under Article 18, but they are reviewed in terms of the principle of legality and the rule of law. The guide also shows so strong is in terms of our Constitution the commitment to administrative justice that the principles of administrative justice has also been extended to political parties. Political parties can't just deal with their members the way they want to. The court would look into your own constitution to see whether you have complied, whether your view or your decision is consistent with your own rules and stuff. Churches, political parties, and even trade unions, and the list goes on. And this is what the guide is affirming. The last one, my last commentary, is on directive principles of state policy. Chapter 11, if I'm not mistaken. But chapter 11. Chapter 11. Chapter 11, Article 95. I must choose my words here. No. In fact, it's my least favorite chapter in the Constitution. My least favorite chapter in the Constitution, to be very honest, and I stand to be corrected, we will not be worse off if we were to take out this chapter, especially the part where the constitutional drafters fell victim to the Cold War that was still at play at the time when our Constitution was drafted. At the time when our Constitution was drafted, there was a group of companies that felt civil and political rights are the first generation rights. And these are the rights that the state should be, that should much be enjoyed in whatever. And there was this other, and those were obviously countries from the West, like the US, Germany, and so forth. And then there was the other countries, the socialist, the communist countries on the other parts of the world that did not so much emphasize civil and political rights, but for them it was economic, social, and cultural rights. So there was this divide. And the Namibian constitution unfortunately fell foul, if my English is proper, to that divide. The Namibian constitution, as the guide indicates, separate in chapter 3, our Bill of Rights, you will predominantly find civil and political rights. And then in chapter 11, under Article 95, you will find issues that reads like civil and political rights. But they are not couched as civil and political rights. They are framed as directive principles of state policy. And to make it worse, Article 101 of the Constitution says these nice things that the state must do, they're actually not justiciable unto themselves. Don't come to the court and say that they were supposed to. No, the state say they will help, these principles will only help the government to make laws and policies and so forth, and as far as the courts is concerned, is to serve as an interpretive guide. I want to conclude with 2 points. Article 95 of the Namibian Constitution is inconsistent with the African Charter on Human and People's Rights. The preamble of the African Charter states civil and political rights. Now, economic, social, and cultural rights cannot be disassociated from civil and political rights. Or is it the other way around? Economic, social, and cultural rights cannot be disassociated with civil and political rights. And then it makes the strong point, the preamble of the African chapter. It says, the enjoyment of civil and political rights is a conditio sine qua non for the enjoyment of civil and political rights. Social and political rights. Civil and political rights is a precondition for the enjoyment of economic, social, and cultural rights. What would it help someone not to be tortured, to freely express him or herself, as our Constitution provides, but that person doesn't have food to eat, doesn't have water to drink, doesn't have proper sanitation, and so forth? What would it help? People would say, take your peace, take your stability. We don't care anymore. What we care about is the fact that we do not have anything to eat. For the politicians and members of parliament, I say, do us a favor. My clarion call is, we hear that you're going to amend Article 4 of the Namibian Constitution, which is very good. That's the idea of Cabinet has taken, that Article 4 of the Namibian Constitution will be amended so as to give citizenship by descent to those people who fled to Botswana and elsewhere during the German colonial period. Well, do us a favor. Don't just amend the Constitution on a piecemeal basis. Maybe roll it out to amend the Constitution. Because there's a lot of other things where our Constitution needs serious amendment. But for now, based on my commentary on the principles of state policies, I would say amend the Constitution also in this regard. And my clarion call is take ESCR rights, economic, social, and cultural rights. Take it to where it belongs. It belongs in Chapter 3 as enforceable rights, fundamental rights and freedom as guaranteed under international law. it does not belong in Chapter 11, specifically not under Article 95. With that, Dennis, I think